law firms. The courts enjoy considerable prestige and independence and are generally of a high quality in the United States, more at the federal level than at the state level, but even at the state level. The organized bar is very powerful in the United States and is largely committed to law reform in many areas of society. Our law schools are distinguished by international comparative standards, and the quality of American law schools goes pretty far down the food chain. There are really a very large number of excellent law schools so that law students can gain an excellent education anywhere in the country. Substantively, American law is attentive to the interests of poor consumers. Landlord-tenant law is just one example of that. Bankruptcy law is another. There are many areas in which the law is, at least on the books, very responsive to the needs of low-income people. I say law on the books. Law in practice, law in action, as we say, is often different. Like India, American law has successfully managed a quite remarkable level of diversity, minimizing violence and maintaining levels of social conflict that are at least not too socially destructive. In the United States, the veneration of the Constitution is a cultural ideal and a cultural practice. Indeed, some of the ugly political wranglings that are occurring in the United States today in the run-up to Tuesday's election are ones in which both sides invoke the Constitution very seriously as providing the underlying principles for their political positions. The common law is greatly respected in the United States, and the rule of law is generally revered in the United States. But the rule of law in the United States suffers from many deficiencies, especially as applied to poor people in the working class. Lawyers in litigation are very costly. Legal aid provided by the organizations that I mentioned earlier is limited, especially in civil cases and in cases involving welfare claims and in misdemeanor criminal cases. In felony cases, defendants are guaranteed a lawyer under constitutional interpretation of the Sixth Amendment. That does not apply to civil cases. There's much bad lawyering in certain types of what I call poor people cases, particularly criminal cases and immigration. There are some areas in the United States where the justice of American law is widely criticized by many foreigners and by some Americans. But this is more about what the law's content should be than about the existence of the rule of law. Capital punishment is one area in which the rule of law is on the books is very, very cherished in terms of the principles that guide the courts in administering capital punishment, but in reality, capital defendants often receive incompetent representation and are under severe disadvantages. In the United States, there's much deference to market-driven outcomes. Respect for markets is in American DNA, and that causes many people to believe that the outcomes of legal disputes and of political processes more generally ought not to be regarded as legitimate. But again, I think that relates more to the content of law than the ideal of the rule of law. The apprehension and detention and interrogation of terrorism suspects has, as you surely know, given rise to many bitter disputes about whether the rule of law is being observed by the government in the conduct of these activities. The law of war is different and less protective of suspects than ordinary civil or criminal law, but again, and this statement I think is controversial, but it's a position that I've prepared to defend, this does not mean the absence of the rule of law. Again, I call attention to the plurality of legal regimes, each of which can plausibly and sometimes convincingly lay claim to being consistent with and advancing the rule of law. There is robust debate in the courts and in civil society in the United States on how different these legal regimes must be under our Constitution in order to continue to enjoy the legitimacy of the rule of law. This debate itself is governed by the rule of law. The rule of law in the United States is inflected, some would say contaminated, by fiercely partisan democratic politics. At some point, this can threaten the rule of law. Just to provide some examples that may be familiar to you, the decennial redistricting of Congress and of state legislatures, which is about to begin as a result of the 2010 census, is one in which politicians basically write the rules and draw the maps that will govern their own electoral prospects. And that calls into question whether they are doing so consistent with the rule of law. The Supreme Court decision Bush versus Gore, which enabled President George W. Bush to take office, is one that many people on both sides of the political spectrum regarded as a very questionable, if not illegitimate, decision by the United States Supreme Court. The judicial confirmation process is one that is highly politicized in the United States. It's become more so in the last 20 years or so, one in which the legitimate nominations by the president are often subjected to withering criticism and opposition, and in some cases paralysis by the Senate, which opposes those nominees. There are rules governing the lawmaking process in the United States Senate, particularly the filibustering rules, which are themselves violations of the rule of law in many respects. There are respectable arguments to be made for and against particular rules of process within the legislative arena itself, but there are many who believe that a rule such as the filibuster, which enables a small minority to prevent legislation going forward, is itself a violation of the rule of law. So with that, I will end, hopefully launching a larger debate here at this conference on what we mean by the rule of law and how we can best protect it. Thank you.